You're watching 13 WMAZ Law Call, sponsored by Macon law firm Reynolds, Horn, and Servant. Your rights, your calls, live. This is 13 WMAZ Law Call.
Well, hello and welcome to Law Call. I'm Morgan Dukes, and tonight we're going to talk about a very serious and familiar topic, all about injuries. Everybody has been in some type of injury. I hope yours was minor, but if you need an attorney, well, we've got two great ones here for you tonight. From Reynolds, Horn, and Servant, welcome, Mr. Carl Reynolds. How you doing, sir?
Hey, Morgan, how are you doing? Long time
Always.
no see.
Yes. I'm always doing good. And
Right.
we got to fix that. You got to come around more often, huh?
Well, we do. Maybe someday we'll get back in the studio and we can do this together rather than remotely. But for right now, we're doing it remotely. And for tonight's show, I have with me my partner and my cousin, Wendell Horn. He will be helping with the heavy lifting. How about that?
Oh, okay. Sounds good to me. How you doing, Wendell?
I'm doing great, Morgan.
Good. Well, listen, we've got two powerhouse attorneys here tonight, folks. So we're going to get into the meat of answering your questions. And then this is a wonderful thing to have both Carl Reynolds and Wendell Horn. So they got some good answers for you. So on that note, I say let's go ahead and get started because we've got some good questions tonight. The first one has to do with a blowout. And this question says, my brother was seriously injured when a tractor trailer had a blowout right in front of him. And then they swerved into him and crushed his car. Now, I'm sure the driver didn't expect this, but is he still at fault somehow? And where do I start with this? This question comes from Megan.
Well, I would start with going to a lawyer and having the lawyer investigate the wreck and all the facts attendant on that wreck. Now, you asked me earlier if I had a story, and I hadn't even thought about it. But in line with that question, years ago, we had a case where a tractor trailer truck was driving down the road and the left rear tandem assembly came off the truck and rolled forward in the opposite lane and hit our client head on. The injuries were pretty serious. The backstory on that was that the tractor trailer truck, was delivering a load of beer bottles to the Miller Brewing Company down in Albany, Georgia. He had begun to have trouble with his brakes north of Macon, and he pulled into one of their locations here in Macon, and they decided that they needed to do a brake job on this truck. Well, they didn't have a torque wrench, so they could pull the final locking nut to a certain level or degree of torque. And interestingly, the vice president in charge of operations was there, and he told them they didn't need a torque wrench. They could use a chisel and a ball bean hammer to get the locking nut back on the tandem assembly. Well, the driver wasn't too happy about it, but he went on down the road. He got as far as Cordell, and he stopped and he called back and he said, they're still slipping. Again, the vice president in charge of operations said, put it in some kind of a lock mode and go ahead and deliver those bottles. Well, he got about halfway between Cordell and Albany, and another trucker got on the CB and called him up. And he says, hey man, I don't know if you know this, but you've got all kind of fire and smoke coming out of your left side, right behind the cab. And the truck driver says, I don't care. I was told to get these bottles to Miller or I'd lose my job. Well, it wasn't a minute or two later that whole tandem assembly came off and rolled forward and hit our car head on. Now, the question was about responsibility. Actually, it was for a blown out tire. This case involved a big company. It involved people in management, and it involved a truck driver. Well, the truck driver has a responsibility to make sure the truck is in a safe condition before he takes it out, right? Certainly under the doctrine of what we call respondeat superior, the company has a problem because the driver is an agent of the company. And in this case, I would think the vice president in charge of operations ought to bear some personal responsibility. Well, I'll end the story with this. We went to trial in Fulton County, and we tried the case for 3 or 4 days. The jury went out, and what was a seemingly pretty clear situation, they stayed out for an inordinately long time. And judge called her back once, and you know, the usual thing, how y'all doing? You making any progress? And then they went back. We thought about it and decided that probably they were reluctant because the case involved pretty substantial damages. It's going to be a big verdict, whatever the verdict was. And the truck driver had come off as a pretty good Joe, that he was just doing his job, as a blue collar guy doing his job, kind of caught betwixt and between. And so at that time, under the law, you could dismiss any time before a verdict came in. So we dismissed the suit against the individual driver without prejudice and left it pending against the truck company. The judge, of course, had to call the jury back in and tell them that the individual driver had been dismissed from the case, so they were no longer to consider anything against him. When the judge made that announcement, I saw one of the jurors punch the other one with his elbow. They went out and came back in within about 20 minutes with a verdict for well over $1 million. Now, on the question, getting back to the question, is the driver responsible? To some extent, yes, but it could be the company, it could be the driver, it could be the maintenance shop, it could be anybody. And that's why I said the first thing you do is go get a lawyer, turn the facts over to that lawyer and let him or her investigate the case and find out where the liability may lay.
Okay.
Boy,
Well,
that
Wendell,
was a long answer, wasn't it?
That was a long answer, but that was a great story.
yes, it was a good story. It was a good story. So, Wendell, let me ask you this. In a case like that, or any case, how many times can you sue one particular company?
Well, you can sue a particular company any number of times, but not for the same action, not for the same claim. But what Carl was referring to is there is a dismissal available to a plaintiff where you can dismiss a party or the whole case and refile it within 6 months, and it renews the case. And that's what they did in this case. But, one thing that was not mentioned, a driver does have, Carl did mention, has a duty to inspect the tire. And the question that we had, did the driver do an inspection and was the tire in good shape, or was it low on treads, or was it a recap? And also, what maintenance did the trucking company have in place? But, and Carl can give you a number of stories on bad tires. Those are cases of their own. I mean, it could be that this was a appearance-wise a good tire. It had been looked after. There was an inspection done, but the tire failed, and then you would have a claim against the tire manufacturer if there was a substantial injury.
All right. Well, now you know, if you're driving on the highway, you want to be especially careful because you don't want any problems, that's for sure. Hey, listen, I'm Morgan Dukes, and we'll be right back with more of Law Call next.
You're watching Law Call on 13 WMAZ with personal injury attorney Carl Reynolds, who has recovered more than $500 million for his clients, dedicated to helping injured Georgians for more than 50 years. Plus, support from his Macon law firm of Reynolds, Horn, and Servant, including attorney Wendell Horn, focused on protecting the rights of car and truck wreck victims across the state, and attorney B.J. Servant, aggressively representing those injured by medical malpractice. Hosted by award-winning broadcaster Morgan Dukes, featuring guests from across Middle Georgia. your rights, your calls, live. This is Law Call on 13 WMAZ.
And welcome back to Law Call. I'm Morgan Dukes. And tonight we're talking all about injuries. And if it's happened to you, maybe you were in a car accident or you experienced a blowout or somebody hit you or whatever the case may be, you need to talk to a good attorney. And we've got two of them here tonight, Carl Reynolds and Wendell Horn from Reynolds, Horn and Servant. And gentlemen, let's get back, before we get back to our email questions, Carl, I believe you have a story about a tire, a recap, or maybe, something on a big rig, one of their tires, or tell us your story.
We're still talking about the first question about the responsibility.
Okay.
And that runs wide. We have cases all the time that arise out of some defective tire or rim. In fact, there was one, Wendell mentioned recaps. Recaps are terrible things. You see half of tires in the road a lot of times, and they're big, they're thick. I mean, they would cause a wreck to a motorcycle, certainly. Sometimes they fly off and fly back into the cars behind them. There was a case in South Georgia where a recap came apart on a big tractor trailer truck, flew back and hit the car behind it, and hit something in the front that caused the passenger to be decapitated. The one that Wendell had referenced earlier was one we had many years ago, and it was a 2.5 ton truck used in the National Guard. And there were a number of men riding in the back of the truck coming down I-75, and the tire blew out. The tire was defective. Now that involves a lot in the way of proof of facts. You've got to get the tire, you've got to get the product, you've got to get it to the right experts who can show that it failed because of a defect in the manufacturer. We were able to do that. In this case, really, just a bright young man, 23 years old. I would describe him almost as angelic. That was the kind of person he was. He was flipped out of the 2.5 ton truck onto the side of the road, and it broke his neck, and he was rendered a quadriplegic. That is, he was paralyzed from his neck down for the rest of his life. He lived another 35 years. He and his wife and members of this firm became close friends. We always remembered each other at Christmas times. The wife would come by from time to time with this or that problem, and we were always happy to help her. But that was a direct cause from a defectively manufactured tire.
Wow.
It happens all the time.
That's tragic, but thank God you were there to help them out along the way.
We could go on with tire and rim stories all night. I mean, we had a rim that failed and took the top of a man's head off and rendered him a triplegic. And there were over, I think when we tried that case, when we got all of the data from the defendant, and I can say the defendant in this case because it went to a jury verdict in federal court in Kentucky. It was Bud, Kelsey Hayes, General Motors, Firestone. General Motors, because they put this rim on the truck as original equipment. But the rim failed. It injured this young man terribly. I mean, it was just unbelievable. And that was a 6-week trial. But the manufacturers were found jointly to be liable. All of those parties I just named. And that was a substantial verdict.
Wow. Well, thank goodness you were there to help out. And that's what it's all about, because we're talking all about injuries tonight. And if you need some good attorneys, well, we've got two of them here tonight. Wendell, I have a question for you. Allison sent us a question in, and she wants to know, can you explain the time limits involved in filing a lawsuit over an injury claim? And are there different time limits, for different types of injuries? So, Wendell, what say ye?
Well, Allison needs to see an attorney to begin with. Generally speaking, there's a 2-year statute of limitations to file a claim for an accident. However, there are certain exceptions to the rule, and that's where the pitfalls come in, and why it's always good to contact an attorney. If it's a suit against the city, then you've got to provide the city with the anti-litem notice within 6 months of the date of the injury. It's got to be very, very specific. And if you fail to do that, then you're precluded from bringing a lawsuit within the normal 2-year statute of limitations. So it in effect makes the statute a 6-month statute of limitations. In the case of a county, you have a year. In the case of the state of Georgia, you have a year that you also have to provide this anti-litem notice. Federal government under a federal tort claim, I'm not absolutely positive on this, but I think it's within 1 year of the date of the accident. So there are a number of different time deadlines that got to be met from an insurance perspective. Also, and this is something that is very important when you're involved in a lawsuit, the policy of uninsured motorist coverage that you have on your own vehicle provides that you must give them notice typically as soon as reasonable. Does that mean a week? Does it mean a month? All we can tell you is that there's a case in the state of Georgia that said 3 months was too long. And that's a prerequisite to filing a claim against the UM carrier. If you don't provide them with that as soon as reasonable notice, then a year down the road, you may not even know that it comes into play until a year. You're precluded from bringing that claim.
Wow. Wow. That's why we have good attorneys like you.
So yeah, for clarification, I mean, that was a natural segue into the UM question, but just so the audience understands, if you're in a wreck and somebody else is at fault, they are responsible for your injuries and damages if they were negligent and their negligence caused your damages. And you have these various statutes of limitation. If you go beyond the statutes, then your claim ceases to exist. At least it's not enforceable. That's against the other party. But we harp on this all the time that each and every one of us should have uninsured motorist insurance. That's your own insurance that protects you and actually covers the at-fault driver by contract. And that's what Wendell is talking about. You lose that if you wait an unreasonable time to notify your own insurance company of a wreck in which somebody else was at fault. And a lot of people will say, well, I don't want my insurance company to pay that. I don't want to turn that over to my insurance company. Well, it doesn't count against you at all. But you have to put your insurance company on notice anytime you're in a situation where you've been injured by somebody else's fault, assuming you have uninsured motorist insurance. I mean, that's just absolute. And then the other thing you need to think about is the different statutes of limitation in different states. So if there's ever any question at all, you should see a lawyer as soon as possible, especially on that question of uninsured motorist insurance.
Indeed. Carl Reynolds, Wendell Horn, we're going to take a quick break and we'll be back with more of your questions right here on Law Call. If you have further questions for Mr. Carl Reynolds or Mr. Wendell Horn, give them a call or find them right here in Macon at Reynolds Horn and Savant. The phone number is 478-405-0300. You can also find them on the web at www.reynoldsinjurylaw.com. And don't forget to follow Reynolds Horn and Savant on Facebook, where you'll find a lot of good information and, find out how they handle other cases. That will certainly lead you right back to them. Now, gentlemen, we do have a question here, an email question that came to us from Lynn, and she wants to know about a bad car wreck. So listen to this. I was in a bad car wreck and spent 2 weeks in the hospital. Now, I just got a call from the hospital asking if I was going to pursue legal action against the other driver. What business is it of the hospital whether or not she pursues? That's a good question from Lynn. So, gentlemen, how do we start on that one?
That's a great question, Morgan. And let me set it up with the black letter law or the black letter example, and then Wendell can elaborate on it. Let's just say you're in an automobile accident and it's the other party's fault. Between your uninsured motorist and their liability insurance, you've got, say, coverage of $100,000 combined, and your medical bills are $150,000 or $200,000. The hospital wants to know, or the physicians want to know, whether you're going to pursue a claim or not, because they are subrogated to the extent that they have provided you with medical care and services. They are subrogated to get that money back from the at-fault driver or from the uninsured motorist carrier. So what is your leverage, Wendell, in that situation?
Well, what they are wanting to know is the information they need to file a hospital lien. And then they get all the money. And the injured party gets none. They're first in line. And the leverage you have, and this is why you should see an attorney, you got $150,000 in medicals, only $100 in coverage. Why should an injured party go through the turmoil, all that's got to be done to go through a lawsuit if they're going to get nothing out of it? And that's the leverage. The hospital under a hospital lien does not have a direct action against the at-fault driver. Only the injured party does. So you can say to the hospital, look, if our client's not going to get some money out of this, they aren't going to pursue the claim. Therefore, that money goes away. So if you do that, typically the hospital will say, let's split it a third, a third, a third, and everybody gets something out of it. And that's the leverage an injured party has that they can place on the hospital through an attorney. And that's why you should see an attorney. And
it's commonly done, but most people don't know about it. It's like playing poker, and the hospitals and the providers know, and they will divide it three ways if you have a lawyer who is aggressive with it.
Now, is that negotiable? Can they, sure. Do they have to divide it three ways? Or
they don't have to do anything. I mean, they really don't. They can insist on all their money, but the client may say, well, if you're going to do that, I'm not going to file a lawsuit. If I file a lawsuit and make a recovery, then I expect something out of it. So most contingent fee contracts are a third. So the lawyer goes to the healthcare provider or the hospital and says, look, why don't y'all take 30 cents on the dollar? We'll take a third under our fee, and then the client gets a third of the 100 that's available. That's kind of the way it's done.
Okay. And that's why it's so very important for, people to contact you. And I also want to point out tonight before we wrap up is that there is no charge for a consultation to come see either one of you. Am I correct?
That's always correct. And there are plenty of good lawyers in this area, but we're happy to help anybody.
All right. Well, I encourage you to go to their website at www.reynoldsinjurylaw.com and, do the questionnaire, get the information, and give you both a call. Gentlemen, I thank you so much for being with us tonight, Carl Reynolds and Wendell Horn. It's been good, and I know we've answered your questions. But until next time, I'm Morgan Dukes for LawCall. Good night, everybody.
Good night, Morgan. Good night, everybody.